Delhi High Court recently restrained Hong Kong-based Crocodile International from dealing with this mark because it turned out to be deceptively similar to French luxury brand Lacoste. However, many of you might not know this, but Crocodile International will continue to use this brand. How? Let's talk about this. In the year 1933, Lacoste was founded by one legendary tennis player, Mr. Jean-René Lacoste. He was also known as the Crocodile, and he co-founded Lacoste along with André Giller, who was a French textile manufacturer. They filed their first trademark in France for their brand Crocodile in the year 1933, and now they wanted to expand to other countries as well. But once they entered into Asian market, they faced their biggest opponent, Crocodile International. Crocodile International, on the other side, was originally created by Dato Dr. Tan Hian Sin in the year 1947 in Singapore. It got its first registration in Singapore in the year 1949. Then it got registration in Malaysia, Korea, Japan, and in 1952 in India. So as I said, Lacoste tried to invade into Asian market and stumbled into Crocodile International. It first tried to establish in Japan in the year 1971. And in 1971, Crocodile International sued Lacoste for infringement, but Lacoste won. In the year 1980, in Singapore, Crocodile International sent cease and desist notice to Lacoste to restrain themselves from using this trademark in Singapore. But Lacoste decided to offer $1 million to Crocodile International in lieu of just coexisting with Lacoste. That let both coexist peacefully. After that, a coexistence agreement was entered into by the parties. Now, as per this agreement and subsequent communication thereafter, Crocodile International will not be objecting to Lacoste trademark application in India and other countries and will allow to coexist alongside. Thereafter, Lacoste also obtained 2 trademark registration in India. So finally, after the year 2000, Crocodile International started to use this brand in India, like standalone without the word crocodile written over it. Now, keeping these marks side by side, one can tell that these are mirror images. Therefore, Lacoste sued Crocodile International, and this matter took 28 years to be adjudicated by the learned single judge. And I'm pretty much sure that cross appeal will also be filed. The Hon'ble Delhi High Court first decided on who is the prior user of this saurian or reptilian logo in India. The Hon'ble Delhi High Court held that when it comes to the composite mark, Crocodile International is indeed the earlier registrant and user. But for the standalone mark, it's not. But what about the coexistence agreement? Crocodile International contended that Lacoste could not have sued them because of the existence of this coexistence agreement. The agreement specifically and expressly mentioned this mark. Therefore, Lacoste should exist peacefully, and I should say coexist. Lacoste on the other side contended that this agreement clearly and expressly mentioned the list of the countries where this agreement will be applicable, and clearly India is not part of that list. Whereas Crocodile International contended that if the overall conduct of the parties is to be seen, it was intended that this agreement shall also be applicable in India, say allowing Lacoste to have registration in India at first place. Also, in another matter which was going on in Supreme Court of China, existing these two parties again, Supreme Court of China held that even though this agreement, this coexistence agreement does not name the word China, this agreement will very well be applicable in China, seeing the overall conduct of the parties. Whereas Hon'ble Delhi High Court on the other side held that it will respectfully disagree with the views held by the Supreme Court of China and held that contract needs to be specific. Then court decided whether this case is of passing off. Court held that during final stage of the trial, court seeks even higher degree of proof from the plaintiff. That plaintiff indeed had a very strong reputation and goodwill at the time of filing of the suit. Now here is something to learn. Court held that Lacoste did not have enough goodwill and reputation as has been claimed during the filing of suit. However, the learning aspect is that Lacoste did put lots of documentary evidences, electronic documentary evidences, to prove its strong goodwill and reputation. But These were electronic evidences and they did not put 65B evidence certificate under Indian Evidence Act, due to which these evidences became inadmissible in the court of law. Therefore, in the terms of passing off, court decided in the favor of Crocodile International. So if I have to give conclusion, Crocodile International is allowed to have this trademark but not this trademark standalone.